these over here. Make sure you get one. I can do wherever you want me to stay. It's easier for me to stay here. Okay, we'll get going with our next presentation. Employment Law 101, our speaker. We're lucky today to have Lisa Marzo. Lisa is a partner at the Boyce Law Firm in Sioux Falls. She's practiced there for over 20 years. Her primary practice areas include employment and government law. She serves as the Brandon City Attorney. Lisa's practice involves providing training in the workplace and pre-litigation investigations to resolve disputes prior to litigation. Her clients include a broad range, everyone from the small employer to those who employ thousands of employees. Lisa is involved in a host of different groups and organizations, the Federation of Defense Counsel, Defense Research Institute. She's a member of the State Bar, the ABA, the South Dakota Defense Lawyers Association. So please join me in welcoming Lisa Marzo.
Well, hello. How many of you are new law students that just graduated or being sworn in today? Just a couple of you. Okay. Well, welcome to everybody. Congratulations to our almost admitted newly graduates of law school and those who passed the bar. Sorry, should have asked how to work.
Yeah, sorry, it doesn't work.
Oh, okay. Okay, great. Sorry. So, mainly I do employment law, and I'll try not to walk through here. I do some other governmental entities, but mainly employment law for about 20 years. So I'm just going to, I was thinking my audience was more towards the attorneys who maybe are just out, and I was thinking through after doing this for 20 years, what I would want to know if I just got out of law school, just passed my bar, maybe I'm going to start advising. Do you want me to have additional?
trained.
Okay. What I would want to know if I just got out or if I just started even being a business attorney. So over the course of 20 years, just different things I've picked up on. And so today I'm going to cover what I call alphabet soup, independent contractor versus employee, employment handbooks. And then I was thinking through, a lot of you maybe were going to be here that haven't hired or fired or disciplined employees, and you're going to be hiring staff, and a lot of times I go and do training for HR, and I thought, well, let me just finish up a little bit on what attorneys so often forget, that they are employers as well. And if you're going to hire somebody, if you're going to fire somebody, if you're going to discipline somebody, performance reviews, maybe what you should be thinking about, because lawyers are not immune from being sued in malpractice or in employment suits either. So those are the basic topics I'm going to talk about today. So I ran and got milk duds. I didn't know you had candy. So when I get to these are the different topics that I thought maybe everybody should know about. So if you just shut out something, you're going to get milk duds. And in all honesty, fair disclosure, I bought these because I stole a bunch of my partner's milk duds. So I bought them to replace hers because I'm a milk dud freak. But I got to thinking while I was sitting here, I'm going to throw them out if you can answer the question. So Title VII applies to 15 or more employees. If you have it, then you, as a private employer, are going to be subject to it. Give me somebody. What's Title VII?
Hostile work environment.
There you go. PDA, that's going to apply to 15 or more employees. Who knows what PDA means? We're talking about alphabet soup here. PDA.
Bad catch.
What? There we go. So SDCL 2013-10 applies to all persons. You don't have to have just 15 or a certain number of employees. So SDCL, anybody got any idea what that is?
South Dakota Codified Law.
Very good. I'll give it to you.
Cheating.
Oh,
it's a good toss.
I'll have to walk a little bit. Fair Labor Standard Act, or
I just want to move it.
FSLA, who knows what that is? Oh, there you go. So that's gonna apply to all, Fair Labor Standard Act, overtime, things like that. EPA,
Environmental Protection Act.
well, it is environmental, but employment context.
Equal pay act.
Equal Pay Act.
Right on.
There you go. So, I'm gonna name this here. USERRA. Uniform
That's.
Service Employment and Reemployment Rights Act. So, that is the one that applies to our military. So, no, I get the no fit for that one. So that's gonna apply to all employers. FMLA, what does that stand for?
Family Medical Leave Act.
There we go. And that's going to apply. If you have 50 or more employees, that's what you're going to want to be knowing that you have to comply with. OS.
Occupation Safety and Health Act, and it's the only way a videographer can get milk duds here.
Absolutely.
Thank you.
That's another like note. If you don't, you can figure it. Okay. IRCA. Immigration. I still got that's Reform and Control Act. I got two. So that's the Immigration Reform Act. If you have 4 more employees, then you're going to need to make sure that you're complying, your employees that you're advising are complying with the Immigration Reform Act. ADA.
Americans with Disability Act.
It was over here someplace. Okay, Americans with Disabilities Act. So if you have 15 or more employees, you got the Americans with Disability Act that you're going to have to comply with. GINA.
Genetic Information Supplement Act.
There you go. So if you have 15 or more employees on that one, you're going to have to comply, and that's all our DINA or makeup or genetic. WARN. Our WARN Act is going to be for our notices, where you have 100 or more employees and you're going to do a reduction in force. So that's what our WARN Act is. FCRA. It's kind of a hint there.
Reporting Act.
Federal Credit and Reporting Act. So that's going to apply to any employer who's doing any background checks. My point being, in employment law, there are so many different types of laws that we have, federal laws in particular, that apply to employers. I didn't get into public employers because that's a whole other area, but just generally speaking, private employers, it really depends oftentimes on the number of employees that you have, whether or not you're going to be governed to that. So when you're thinking about employment laws, those are the primary employment laws. And I'm not going to I could spend a whole day with you on each of these acts. But again, all I really wanted to do today was cover what maybe every South Dakota lawyer should know about employment law and just some little tidbits. General liabilities for misclassification. I thought it was important to make sure that you know that, and what I oftentimes speak about is when you are working with your clients, whether they're employers or businesses, and you're going to go and help somebody form a business, one of the things I really want employers to know is it's so important to have employment practices, insurance, employment cases. As many of you here know, cost anywhere from $75,000 to $150,000 to try. They're just extremely expensive. By the time you get through depositions and motion practice and trial, it is extremely expensive. And when you're dealing with particularly smaller employers, it's still going to be that much money. And if they don't have the insurance, if they just have a general liability policy, and they don't have the insurance, that can be just devastating on their business. So when you're talking to your employers, when you're advising them, make sure you talk to them about getting employment practice insurance. It's a separate line of coverage. It covers for paying the defense costs. So important, because for federal claims in particular, you have back pay, you have front pay, liquidated damages, meaning whatever the amount of money is that's owed, for example, under the Fair Labor Standard Act overtime. It can be double or triple depending on willfulness and misconduct. Interest. Most of these federal cases, these federal claims, there are attorney's fees on the other side if you lose, if your employer loses, and litigation costs. So it's very expensive in terms of employment practice as opposed to personal injury. Those claims don't cost quite as much still to try, particularly at our law firm we found, but employment practices are very expensive because of the damage you can get. Claim statistics, still, when you look through over the course of what the EEOC, Equal Employment Opportunity Commission, provides, still the top 4 are race, sex, disability, and then age. Those are going to be the primary claims right now, and you can go on, and about every few years they might flip in one of those spots, but those consistently have been the top 4 type of discrimination cases that are out there. Retaliation is in about every third of those claims. Somebody is arguing, not only was I discriminated against, but I was retaliated against because I filed this or reported this. And so in about a third of those, statistically, I think it's just important to know what is out there in terms of claims and helping to defend or bring them. Very briefly, just to remind you, Title VII protected classifications include all of those: race, color, national origin, sex, pregnancy, age, disability. If you look at our statute in South Dakota as opposed to Title VII, we add the creed and ancestry, so not much of a difference, but they do add that to the South Dakota statute. What is discrimination? And part of this also should help you in terms of if you're ever sued. Have you ever had discrimination training? Here's your discrimination training. So yes, you are familiar with this, and this is part of what I wanted to do, is to make sure to educate you on what discrimination is. You know, differential treatment, refusing to hire, unjustified evaluations, disciplinary actions, negative references, increased surveillance. All of this can be discrimination. And so when you're talking about the acts, it can be any of this. Needs to create an adverse inference, but it has to be an act or a failure to act based upon one of those protected classifications that I just listed. I'm going to cover a lot of material here, so just bear with me. In quid pro quo, we were talking, sexual harassment. That is part of sexual discrimination. So it's the quid pro quo. You do this for me, I'll do this for you. Or the hostile environment, where you create an environment that is so hostile to that employee that he or she can't do their job in a way that would allow them to do their job. It has to be pervasive, offensive, and a bunch of terms on that. So that was discrimination, just in terms of Title VII. In terms of ADA, just a couple things to think about is, what does our ADA require? Well, again, that employers can't discriminate on the basis of a disability, a physical and mental impairment that substantially limits an activity of daily living. And I will tell you, over the course of the last probably 3 years, the mental impairment is what really becomes difficult in terms of advising our employers of how to deal with somebody. I'm depressed, I'm stressed, I'm not coming to work on time because I'm sad. That can be a real disability. And so when you get that information from your client, or you yourself as an employer, you need to make sure that you understand that the mental impairment can be a disability as well. And you may have to work through the ADA with respect to what you're going to need to do. Medical examinations, there is more emphasis now, I believe, put on the medical examination, when you can do a medical examination, under what circumstances you can do a medical examination. You can't just wholesale say, oh, I think I have an employee who has some type of condition, I'm going to have a medical examination. It used to be done very routinely. Now you need to make sure there's a real reason that you're doing a medical examination. There needs to be a direct threat to the safety of other employees, to that employee, a real reason why you think you need to do a medical examination. And so when we look at and I say ADA, it was amended back in the late 90s, so it's actually technically the ADAAA as Amendment Act. You're talking really about the significant risk of harm to the safety and health of others, that you can do the medical examinations. And it's not just a wholesale, do a medical examination and your diabetes A1C level is such and such. You can't just exclude people anymore on the basis of some condition. You have to really go in and look at, well, just because this person, for example, is diabetic, does that mean it's going to impair their job? So employers no longer can just simply say, here's things that are going to exclude people from doing a bus driver job. Here's what's going to exclude them from being a heavy equipment operator. Employers have to go in, if you're going to do a medical examination, and truly look at that person's, what they can and cannot do, not just do they have an underlying diagnosis, and then make a real decision based upon that person's individual assessment. important to know that you can't just wholesale, and I think people in the HIPAA era that we live in know that we can't just simply send things out to everybody in terms of once you do those medical examinations. Rather, instead, you have to only tell the people who have a right to know, who have a need to know, supervisors, for example. Maybe not every supervisor needs to know. So the ADA has built into it real protections that are there so that coworkers don't know and supervisors who don't need to know don't know. So within the ADA, when you're talking about doing these examinations and discussing conditions, there are parameters by which you can and should not disclose things. You know, first aid, safety personnel, those would be some other examples that maybe you can disclose. Covering a broad things here. So what I'm really trying to do is just give you an overview of some of these employment laws. So FMLA. FMLA is the 12-week protected leave. It can be intermittent, so you don't have to take all 12 weeks at the same time. It can be, you know, an hour increments, and you add them up over the course of. It's for the employee's health condition, serious health condition. There's a lot of qualifiers as to, you know, what's serious and not serious, but there's plenty of law out there to help you make that determination. So the employee's serious health condition, for the adoption or birth of a child of the employee, care for that employee to provide, or time for that employee to provide care to an immediate family member, mom, dad, spouse, child, is defined in the law who they are. And those individuals have to have a serious health condition. And more recently, FMLA provides a qualifying military family leave. So if one of the family members is going to be gone for the military, now within the parameters of FMLA, there is qualified military leave. It's not for all employees. They have to have a certain baseline, and all you have to do is Google FMLA, and you get the EEOC guidelines on there. So you can look that up at your leisure, but you have to be employed for 12 months, and your hours have to meet a certain threshold. So an employee who comes in doesn't get FMLA the first day that they're there. They have to first meet the 1-year requirement and the hour requirement. You know, the reasons for FMLA really make sense. We're trying to promote letting employees who've been there long enough go out if they have a serious condition or their family has a serious condition, where they're a big enough employer, you know, we saw previously the 50 or more, to be able to have that employee have a little flexibility in going out and taking care of themselves or somebody else, or having the leave for adoption or for birth of a child. And the protections that you're getting under FMLA is for a reinstatement to the previous job position. There's some, obviously with everything, there are going to be some limitations and restrictions on some of that, but generally speaking, it's reinstatement to the position. And it also addresses benefits. So what you're going to do with the benefits the employee has when they're out. Is he or she going to have to pay for their medical insurance? It talks about accrual of vacation time. And so there's a whole host of things that you're given under FMLA leave, and I would just have you go and look at that as well. One of the interesting things that has progressed over the course of the last probably 10, 15 years used to be once your 12 weeks is out, you could just terminate that employee. And some employers still are under the misimpression of that. So you need to make sure that you're visiting with your employers about how, no longer under the FMLA, when you get done with your 12 weeks, can you go ahead and terminate that employee if it's for the employee's own health condition. You have to now give consideration under the ADA whether that person has a disability. And if they have a disability, then to decide whether or not you can reasonably accommodate more leave, for example. So no longer can you simply tell your employers, yep, you're done with your 12 week with that employee. You now have to start thinking, is there a disability? Can I reasonably accommodate? And it all depends. There's no hard and fast 1 more week of leave versus 6 months of leave. It really depends on the employer that you have and whether or not that employer can accommodate more leave and whether that's a reasonable accommodation. You also need to think about other open positions at the end of that 12 weeks. Maybe they can't come back to this one, but maybe there's a different open position and you want to be engaging in that type of process. And you want to document what it is you did instead of just simply saying, we've decided, hey, we can't accommodate more leave. You want to document that not only did we consider this position, we considered all open positions for which they are suitable. Have your employer go in and document something to that effect. Fair Labor Standard Act, basic. I have had a number of times in my practice where a business attorney formed a corporation for somebody. but didn't talk at all with that corporation about overtime, the Fair Labor Standard Act, overtime obligations, and misclassified employees. So particularly if you're thinking you're going to have a business practice or you're just advising clients in the employment world, there are employees that are exempt from overtime and employees that are not exempt. And if they really don't know, tell them to pay the overtime, because the penalties for not doing it are significant enough that you're not going to want to mess around with that. Basic conversations with the employer about what are the job duties, and there's a lot of classifications, administrative. There are several different classifications of whether or not you're going to have to pay somebody overtime, but don't just wholesale when you're talking to your businesses out there, informing them, forget to talk about overtime. Truck drivers, for example, they may be exempt, they may not be exempt. You really have to get to know what your business practice is with those employees. Paralegals, for example, the law continues to evolve. When I started practicing, paralegals, we didn't pay them overtime. Our federal government changed that and said, no, they need to be paid overtime. So you have to keep abreast of the developments in all of these different employment areas, because it used to be, for example, they were exempt, no longer they exempt. And so point there being, just keep looking at things and don't rely upon something that was quite a while ago. Time spent working after hours. There's a whole host of things out there in terms of if your employees are going to have cell phones and have to check their cell phones or check their emails or be on call. If you are working with employees like that, or employees who have it, make sure you understand that there are and can be obligations to pay those employees overtime. Coming and going to work, there may be obligations depending on job duties of paying overtime for that. And you really want to make sure that you're talking to your employers to tell them where the employees are not taking overtime. You need to sit down and have those discussions with the employees about, no, you need to document. We need to make sure we get your records. We need to make sure we're paying you overtime. This is not just to protect the employer, but it's also fair. It's the right thing to do. And so make sure you're doing a review, telling your clients to do a review of what their employees are actually doing. Volunteers. That's a whole other area of volunteers. So just be aware that you can have you can have your employees doing certain volunteer things, but it can't be related to that which their normal course of duties are. So you have a teacher that is going to take tickets. Well, their normal course of duties may not be taking tickets as a teacher, and they may be exempt because they're a teacher, but the Fair Labor Standard Act is going to control on whether or not you have to pay them overtime for those ticket-taking hours. Golf course people that are going to go in and run a benefit. If they're an employee of the golf course, are they really truly volunteering, or is that part of their job duties? And so just know, just because you have employees out there saying, hey, I'm going to volunteer this, it doesn't mean they can volunteer this. So when you talk to your employers, make sure that you go in and look at the regulations as to whether or not you can have volunteers. Legal interns, that's a whole other area. If you're going to employ a legal intern in the summer and not pay them, can you do that? And I'll tell you, there's a whole bunch of cases out there on whether or not you can do that. It all depends on what you in your practice have for other employees out there in terms of do you have anybody, are you paying anybody to do those things? What is this legal intern going to do? So just know in your own practice when you go out, if you're going to hire one of the law school students to do some work for you, go in, do some research, figure out whether or not you can do that without paying them or whether you have to pay them. Independent contractors, they're not an employee, so they're not covered by the Fair Labor Standard Act. And we'll go through independent contractor just very briefly here in a second. So you really need to know, are they an employee, are they an independent contractor for your employers that are saying, well, this person's just an independent contractor. Retaliation occurs when you take an adverse action against an employee because they engaged in the protected activity. I reported I was sexually harassed, now I got disciplined. That would be an example of retaliation. So you really need to make sure that you have protections in place for your employers, instruct them, guide them a little bit on if you have a complaint of something, what to do, if there's some performance problems later with that employee, to make sure that you're not retaliating against and there's a break. It applies to all those discrimination. FMLA, ADA, Fair Labor Standard, so many different types of claims. Yes, you certainly can have a retaliation. And quite frankly, they're easier to prove sometimes. And that's why I think they're out there, because oftentimes it might be hard to prove that this is a hostile work environment. But yet, it might be easier to prove, well, I complained about it, and then I was fired. And that's kind of an easier burden sometimes. And so those claims are on the rise. So you really want to make sure that you're advising your employers to step back, take some time before they engage in actions against that employee so that they can make sure they're not doing it in a retaliatory manner. Attorney's fees are recoverable in most federal claims in employment. They're not recoverable under the South Dakota statute that we just referenced. So if you're going to be bringing a claim as a plaintiff's attorney, you want to make sure if you're trying to protect that attorney's fees claim that you're not doing it just under South Dakota law, but you're doing it under the federal laws that we talked about as well. Administrative claims. Just wanted to briefly let you know what the administrative process is. We have the administrative process, the EEOC, we have the South Dakota Human Relations Commission, and in Rapid City and Sioux Falls, and I'm not sure about the other cities because I haven't been there, but I know those two cities have their own internal city one, so the Sioux Falls Human Relations Commission, for example. There are the claims, the Title VII claims, ADAA, Pregnancy Discrimination Act, and the related retaliation. Those are administrative claims that need to be brought first within, or those are the claims that need to first be brought within the administrative agency, the EEOC,